a U.S. person moving abroad. So when we have a U.S. beneficiary moving abroad, one of the most typical questions that I get asked in my practice is, does that cause my trust, a trust where that person is a beneficiary, to become a foreign trust? And typically the answer is no, because we test all trusts under a two-part test that looks at who are the decision makers. If all of the decision makers, even if they're living abroad, are U.S. citizens or green card holders, the trust could still be a U.S. trust.
Welcome to another episode of the On Point podcast. I am David Savir, CEO of Element Point. Today, I had the privilege of speaking with Sarah Jacobson, who is chair of the Latin America practice of the law firm of Pitney, where Sarah focuses her practice on advising global high net worth families on tax, estate, and other legal matters. Sarah and I also went to law school together, so it was a fun reunion for me to get together again with an old law school classmate, but also somebody who is truly expert in her field as an advisor to global high net worth families around the world. So without further ado, I hope you enjoy today's discussion with Sarah Jacobson. Sarah, welcome to the On Point podcast.
Thank you. It's great to be here.
Yeah, so you are the first law school classmate of mine.
That's amazing.
That is on the podcast, which is awesome. This is kind of a full circle moment, even though we lost touch for probably the better part of like 15 years. We were reconnected recently by mutual acquaintances.
That's right.
Which is great.
Right.
So before we launch in, we're obviously here to talk about tax, but more specifically, the considerations and implications for U.S. families primarily that have nexus or some sort of connection within the family or through their investments to non-U.S. Markets. But big picture, would love to just learn a little bit more about your practice and what you focus on, because I know that's a small subset of the issues that you help clients with on a day-to-day basis.
That's right. So my practice is international estate planning. I work with global families that have some U.S. touch point. So sometimes it's U.S. beneficiaries as part of a broader family group. Sometimes it's just based on the U.S. assets. So foreigners will inbound invest into our U.S. markets, into the real estate market is really typical for Miami. So there's really two aspects of my practice. There's inbound, which is predominantly Latin American families that have diversity of residency. So maybe half the family is U.S., half the family is living back at home in a Latin American jurisdiction. They have big operating businesses back in Latin America, but also some U.S. assets. So we're helping them organize their global affairs in an efficient way from a tax perspective, taking into account that we have U.S. people. The flip side of the coin is the outbound part of the practice, and that's what we're going to talk about a bit more today, which is U.S. people who invest abroad or decide to move abroad. And one of the interesting trends in my practice for, the last 5 years or so is really the diversification of U.S. people, U.S. citizens looking for second passports, looking for additional residency, looking to diversify their portfolio in different ways and divest of U.S. investments and really look more globally. So it's the inbound and outbound, and today we'll be focusing on the outbound part.
Yeah, absolutely. I think it's somewhat unexpected among people that for U.S. clients, which is the majority of our business, there's still all of these international tax issues that arise. But the reality is it's such a global marketplace. So for U.S. families now, you have family members who maybe have moved abroad, perhaps the second generation because there's job opportunities there or careers that they've pursued and been relocated for those careers and just stayed. You have families that are investing in markets all over the world, and not necessarily just public markets, but actually buying property in different countries. And all of that creates all of these tax implications that they're often unaware of, and sometimes unaware of at the time that they're making these moves or buying these properties, but it's so hugely important. So I'd love to start on sort of the first part of that, which is the scenario where a U.S. family has non-U.S. family members, which seems to happen a lot. I know we certainly have clients where family members have moved abroad, and there's this complicated connection between estate planning done in the U.S. and what happens to that estate planning when somebody moves abroad. So, many people are not aware. Some countries, Spain for one, doesn't even recognize the existence of trusts or the validity of trusts. So, you wind up in scenarios where if you have a beneficiary who lives in one of these countries that doesn't recognize the validity of trusts, what do you do? So take us through kind of the thought process when you learn that someone has a family member moving or living abroad and they're a U.S. family, but for that nexus to the family member that's abroad. How do they plan for and think about that in the context of their planning?
It's such a common scenario. I mean, we have a lot of, structures that are based in the US. US people typically use US-based structures. Foreign trusts have all kinds of implications for US beneficiaries. There's onerous tax and reporting. So the typical US family is going to have their structure after the lifetime of the grantor, the person who funds. It's a non-grantor trust. And we're all pretty familiar, I think, in terms of estate planning, where you've got that trust that continues, for many generations in a US state. Now, there's really two permutations there. One is a U.S. person moving abroad. So when we have a U.S. beneficiary moving abroad, one of the most typical questions that I get asked in my practice is, does that cause my trust, a trust where that person is a beneficiary, to become a foreign trust? And typically the answer is no, because we test all trusts under a two-part test that looks at who are the decision makers. If all of the decision makers, even if they're living abroad, are U.S. citizens or green card holders, the trust could still be a U.S. trust. Even if, a U.S. person's living abroad and they're a trustee or they have withdrawal powers, you can still have a U.S. trust. The second part of the test looks at whether a court in the U.S. would exercise jurisdiction over the administration. When you have a single trustee and it's an individual, we typically look at the residency of that individual. So in a scenario where you have a U.S.-based trust, a U.S. family member is the trustee, and they move abroad, if they're the only trustee, I would worry that we could create a foreign trust, because a court in the U.S. may not have jurisdiction over issues of administration. It may be that the residency of that trustee, in being in that foreign country, a court in a foreign country would have control over all of those issues. So you could actually outbound the U.S.-based trust, create a foreign trust if it's the only trustee. So it's not the most typical situation where that would be the only trustee, but I've had cases where, for example, the only trustee was a U.S. citizen, decided to move to the U.K. Not only did he outbound the trust or create a foreign trust by moving, no longer meeting the court test here in the United States, but also created a U.K. resident trust. Because in the U.K., they have mind and management concepts. And once he was, the trustee administering the trust in the UK, now we also had a UK resident trust. Now, if that happens, there's an exit tax that occurs. It's a mark-to-market exit tax on the value of the assets of the trust. When a US trust either transfers property to a foreign trust or outbounds, becomes a foreign trust, migrates, there's an exit tax. And it's the income tax event that we're trying to avoid. So in a typical situation, a family should seek advice before one of the family members, even if a U.S. citizen is moving abroad, just to make sure we have either a co-trustee anchoring it here, and also to understand what's happening on the other side of the border. To your point, a lot of countries don't recognize trusts, and we don't want to create a foreign tax issue. So as part of my practice, I'm always looking at it from a U.S. tax perspective, and I'm always seeking advice from a foreign law firm. I know the issues that we're going to talk about today, I'm very familiar with these issues in the UK, Spain, Italy, because I work with those countries often. But that's not to give advice on the laws of that country. We always bring in foreign counsel, and they advise us as to what's happening on the other side of the border.
That makes sense. And on the example that you gave with the move to the UK, I mean, I imagine I've encountered these types of situations as well over the course of my career. I think often what you find is that the issue is resolved by having a U.S. trustee appointed or a U.S. investment direction advisor, but obviously you give something up there, which is the control you may have had otherwise if you were the trustee of that trust that's now moving abroad. So,
That's right. That's right. But let's talk about the second situation. So that was where we actually have a foreign family member, right? Because as families are becoming more diverse, you may have a child who marries a spouse who's not a U.S. person. You may end up with descendants that are not U.S. people. And when they control substantial decisions with respect to a trust, you can end up with a foreign trust. Mm-hmm. To give some common examples, powers to remove and replace the trustee. It's such common drafting. We just always give descendants the power to remove and replace a trustee. But if you end up 2 generations down and a foreign person holds that power, that once U.S. trust can actually be treated as a foreign trust and create that exit tax. So there's typically with my drafting, because I'm so used to seeing the issue, we'll have savings language in there, but it's always important to just understand if we're ending up in a generation that either has U.S. people living abroad or foreign beneficiaries of the trust, we need to be mindful we may be creating a foreign structure inadvertently.
Yeah, that's interesting. I hadn't thought about the beneficiary's ability to remove a trustee as a power, but that makes a lot of sense actually. And so, how do you see? Like, I think there's the legal element to this, and then there's sort of the interpersonal dynamic where, what can often happen is if you have some family members who are abroad and some who are within the U.S., often by necessity they have to be treated differently,
Yes.
right? But from an interpersonal standpoint, from a family dynamic standpoint, that can create some issues or some tensions. So, I think certainly in my role and sometimes in yours, you sort of have to play, family consultant or therapist in addition to, the sort of day-to-day role. So, I mean, how do you think about that? Thinking through the scenarios where just by design, there are certain family members that might have to be treated differently as a result of the planning, and communicating that in a way that everyone understands and where no one is kind of offended by that dynamic.
Sure. No, it's one of the more complicated conversations, actually, because most families, and I see this a lot with my inbound practice, particularly Latin American families, like to be co-invested. They like to remain together in a structure and make decisions together. There's a number of ways that we can deal with that. Although for the U.S. people, you're going to be better off with a U.S.-based trust structure because of the confiscatory rates of tax that apply to foreign structures with U.S. people. You can have a foreign structure for the foreign beneficiaries that co-invest in a common investment vehicle. And that's where it's really interesting to be able to work with investment advisors that understand these points, because we could form a partnership or we can form an entity through which the different trusts invest, just like separate shareholders would invest. So you can keep a family together. I think most of the time, if they realize they can still co-invest and make decisions together, even though it's through different shareholder level vehicles, that's really helpful to a family.
Yeah, that's a great point. And sometimes, by the way, it goes in the opposite direction, which is you have families that may be invested together for generations, but now you get to cousins or second cousins or, whatever generation you're on. And it no longer necessarily makes sense because, as you and I have experienced, it's one thing for siblings to invest together or maybe even cousins to invest together. But once you get a few generations down the road, it's very hard for everybody to have an alignment of goals and objectives. I mean, everyone has their own families and views on the world, and that becomes a complicated issue. So in some ways, it can be better at times to invest separately than together. And in some cases, it's better to invest together.
Right. We want a family that's all kind of working together. So the family does have to be bought into that concept.
Yeah.
I think the broader picture point is flexibility.
Sure.
Right. So whenever we're talking about a dynastic structure that's meant to last many generations, foreign families are becoming U.S. and they're going to have U.S. touch points. U.S. families are becoming more global. So as the world just generally becomes more global, we have to have a lot of flexibility built into our plan, and that's the best solution. So we can have family members come in and out of co-invest in a pretty fluid way.
Yeah, that makes sense. Well, pivoting to another consideration that comes up all the time, probably even more regularly than the first, is this idea of what happens when you own property outside the U.S. So a lot of families that we work with, and just high net worth families in general, they may own second homes. Sometimes those second home or third homes, and sometimes those homes are in the U.S. Sometimes they're abroad. They may be in Europe. They may be in Latin America, even Canada nearby. But yet, the laws that might apply to that property are very different than what might apply to their property in the U.S. from an estate tax perspective.
That's right.
And so what are the things that families and investors should be thinking about, right? So if it's my dream to own, and it kind of is, to own a property in Tuscany, for example, what do I need to,
dream.
it's a great dream, right? What do I need to be thinking about before I make that purchase, insofar as it may impact my planning?
Yeah. So there's really two elements here that we're thinking about. Well, maybe more, but I think the two primary considerations are really tax and succession. But let's start with succession, because in other countries, they may have rules that are very different than the United States. A lot of civil law countries have what's known as forced heirship regimes. So upon your death, you don't have total freedom of testamentary disposition. You can't dispose of your assets 100% as you wish. Local laws will govern. And particularly with real estate, local law is always going to govern when you've got property in the situs jurisdiction like that. So we have to be thinking, are we in a country like Italy that has a form of forced heirship? When you pass away, it's not 100% necessarily going to go by way of your will. The other piece of that, of course, is tax, but we'll get there. So what's interesting about Europe in particular, EU nation states in particular, if you're a resident of Florida or you're a citizen of the United States and you were a resident of Florida, for example, and you purchased a property in an EU state, you can actually make what's called a Brussels 4 election and have the law of your domicile or your citizenship state apply to the disposition of that property. So rather than being stuck with Italian forced heirship rules, you can have testamentary freedom, but you have to make that election in your domiciliary will. And you would do that in your Florida will, for example. The other way that we deal with succession issues like that is to change the situs of the asset. You own real estate, but what if you own that real estate through a company? What's very common is to change the situs. You're changing the character of the asset. It goes from an asset that's governed by local law to an intangible. What you own now are shares of stock of a company, and that's going to pass pursuant to your domiciliary document. But this is where we really have to work with local counsel in Italy, who can opine on what's the best way to do it. There may be a transfer tax in Italy associated with putting a property in a company, so we have to understand that.
Yeah. And then even beyond that, I mean, one question that I would have is, certainly you could have, so in that example, you may have a Delaware LLC that happens to own, a home in Europe. And certainly that makes sense from a probate perspective or otherwise in the US, but will Italy, for example, accept that, or are the laws there or elsewhere, such that you may do that, but it's immaterial with respect to how that country views the property and how that property is owned?
That's exactly why we need local counsel, because it can. Yeah. So we always check to make sure that's going to work. If we're not able to make this Brussels 4 election, so that only applies to EU member states, and it only applies if you're, for example, a citizen of a country that doesn't have forced heirship, and all of that works, right? So if you had like a British citizenship and you could rely on that, maybe you do that to overcome it. But if you're buying property, what's really common, for example, Costa Rica is a really common place where people buy, a vacation property and they're very happy, and you can't make this favorable election. So the question is, can we put it in a company and overcome local forced heirship claims? And that's where I need local counsel to confirm that it works.
Yeah, that makes a lot of sense. And many of these jurisdictions, as you allude to, have some sort of treaty with the U.S. In your experience, I deal with these a lot from an investment income perspective, but from a planning perspective, from a succession standpoint, do you find that these treaties largely cover the vast majority of the scenarios that may arise, or do you find that there are a lot of gaps?
There are a lot of gaps. I mean, when it comes, and particularly with real estate. So real estate is one of those assets where the situs jurisdiction, or the place where the property is located, is always going to have primary taxing jurisdiction. And then if you're a U.S. citizen, for example, we're going to tax you on a worldwide basis. So what the treaty is trying to do is apply credits. But there are plenty of instances where the treaties don't really resolve all of the issues. France is a great example. France is one of those countries where the IHT, their version of our estate tax, they're taxing the donee on transfers, and our treaty doesn't resolve all of the issues. I've had many situations with French, U.S. people living in France, beneficiaries of trusts. France looks right through the trust, and you'll have mismatches, and the treaty doesn't resolve it. So it's very interesting. I mean, our estate and gift tax treaties are rather old, and they certainly do not contemplate all of the forms of ownership that we see today with global families.
Yeah, and it seems like with families today, they may have to deal with jurisdictional issues across numerous countries. And there's many instances that I can point to where you have property in Europe, but also property in Latin America, and maybe a home in Israel. And so resolving all of the different complexities that come with the various different treaties, I think is a massive project, and probably the main reason somebody would pick up the phone and call you to understand like what I do here.
Right, and it shouldn't overwhelm clients either. I mean, there's a point of you're making the investment. Our goal is to preserve that wealth, and what happens is, thinking about this, property in Italy, well, it's a small piece of the pie. Maybe we don't need planning. Can actually lead to a family forfeiting the asset. I mean, a lot of times we can deal with assets in other countries like real estate with situs wills. So a very simple way that you can deal with the asset is to have a separate will that's probatable in that jurisdiction that deals with that asset. And some of the questions that we need to resolve are, how is tax going to get paid? So this is the other piece of it, not just succession. So the situs will govern the succession, but also understanding the tax implications. Is there a tax in the other country? Are we getting a marital deduction in the United States? We're assuming maybe that it's all going to the surviving spouse, but if there's forced heirship, it isn't. So we really need to understand, where does the family want the tax to be paid? Sometimes if the donee is the person who's responsible for paying the tax, we may not want the tax to be paid from the property. We don't want a forced sale of the property to pay tax. So it's thinking through all of these issues, and really just being proactive about the planning can resolve a lot of the problems on the back end, which may make the investment sort of worthless.
Yeah, yeah. That's interesting. I hadn't really considered the forced heirship consideration. That's fascinating. So one issue that is, I don't know that it comes up a lot, but it's certainly coming up with increasing frequency, and you had alluded to it earlier, is the movement of U.S. person outside the U.S. Where they decided to live abroad. Now, I actually see this happen quite a bit with Israel. I have a lot of friends who live or are from there, and many of them, or many people in the U.S. decide, when I retire, I'm going to buy a place there and spend my time there. Actually, a good friend of mine did this recently, retired, and is going to be there. So and I use that just as one country example, but how do you advise and help clients who are thinking about living permanently in another country for whatever the reason may be?
It actually is coming up more and more in my practice. I mean, as we were talking about initially, U.S. citizens looking for other passports or residencies. Sometimes you'll have U.S. citizens that want to go on the Beckham regime, or they go to Portugal or Italy on forfeit. So there's different U.S. people move abroad for a number of reasons. Sometimes they think it will get them out of U.S. taxation, which is not the case if they're a U.S. citizen or a green card holder. As we know, they'll still be subject to worldwide tax. But there can be many reasons why they're looking to diversify, or maybe just spend some time in Israel. That's a very common one also. That's really where all of the issues that we've talked about so far are on the table. You have succession issues that you need to think about. Does the other country, do they have community property? Do they have forced heirship rules? Do they have inheritance tax? Who's subject to the tax? Is it the donor, like we are, an estate pays the tax, or is it the donee who's inheriting the property? So that's really where it's worthwhile to have a holistic review of the estate plan and make sure it works. So even moving to a common law country like the UK, the US and the UK, we have lots of clients that are always kind of moving in between the two countries. And something as innocuous as a revocable living trust that most people that are US citizens have. So for example, you move abroad with your revocable living trust and you're the sole trustee. I would worry you would create a foreign trust from a US tax point of view. Now, it's not a tax issue, but it's a reporting issue. So then that can trigger 3520A reporting and all kinds of reporting that you would want to tell your accountant about. The other side of it is, from a UK perspective, if you continue funding that Rev Trust, right? All of the Florida lawyers, all the US lawyers say, fund your Rev Trust so we don't have probate when you pass away. Well, in the UK, if you're living in the UK, that's treated like a real trust, as if you've made a completed transfer. And you can actually trigger 20% tax up front on a funding of a revocable trust. So this is where we really have to understand, when do you become subject to all of the rules of that country? Or is there a special regime that applies to you? Or does your estate still pass how we want it to pass under your domiciliary documents, which were once US? The other piece of this, when people are moving abroad, that I think comes as a surprise to them from the income tax perspective, is that as they make investments abroad, we have rules, anti-deferral rules, that apply to U.S. people who own interests in non-U.S. corporations, just like we do for foreign trusts. If you have majority U.S. ownership, so client moves abroad and starts, their local attorney tells them it's really wonderful to invest in Italy through corporations. The client could end up owning controlled foreign corporation. That's where it's majority U.S. owned. Probably more common for your listeners is that when U.S. people make investments, for example, in non-U.S. fund of funds, some private equity investments, these investments can be considered passive foreign investment companies, or PFICs. And when a U.S. person owns an interest in a PFIC, and they either dispose of that interest or they receive a significant distribution, there are back taxes and interest charges over their holding period. And that comes as a real surprise, and people can get whipsawed with the income tax thinking that they're making an innocuous investment that isn't. So there's all of the issues are really on the table when a U.S. person decides to move abroad. You have succession issues to think about. We've got estate tax issues to still consider, crediting issues, and income tax. It's really the full array of reviewing an estate plan.
Yeah, absolutely. I think PFIC is often overlooked by people who are making investments or operating businesses or investing in operating businesses abroad. We see that quite a bit. So I'd love to explore your process a little bit because like we covered a lot of different considerations that are important either when moving abroad, investing abroad, or having family members abroad. Now, I imagine when a client comes to you, much like when they come to our firm on the wealth management side, the initial conversation probably revolves around some acute issue that they're having. But in order to really understand, diagnose, and figure out how they should move forward, it's really important to get sort of the much bigger picture because they probably have that one issue on their mind, but it's one of maybe 25 issues they actually have to address where they haven't really considered the other 24. So tell me a little bit about your process. So a client comes in and meets with you. Maybe they're considering buying a property abroad. Maybe there's a family member that lives abroad. Where do you start?
Right. So we get copies of what they have to begin with. So we would take copies of all of their estate planning documents they may or may not have in place, and a balance sheet. I think it's really important to get that holistic picture of where is your wealth, where are your children. So we have a questionnaire that we've developed that helps us solicit those answers, to help us see, are there lingering issues the client isn't even aware of? Like my child living in Spain, that might be a problem because Spain doesn't recognize trust, if we talked about. So it's about getting that holistic picture. And then, of course, we can address the acute issue that the client has on their mind. But once we see what they have globally and we understand who's a citizen in your family, is your wife, sometimes spouses, they may be living here, they might be domiciled here on a green card, but not necessarily a citizen, where there wouldn't be a marital deduction. So it's that kind of a questionnaire that gives us the holistic view of a client's plan and where their assets are, and that helps us diagnose things that may not be on their mind.
Yeah, no, it's important to operate with complete information. I think we encounter this all the time in our business. We've spent the better part of the last 3 months actually working on sort of an improved digital intake form, if you will, right? That sort of that is dynamic and evolves to ask some of the sort of intuitive next questions as you go along. Because I think to your point, you have to have a complete picture in order to know where to begin, because so many of these things are interrelated. You may, try to resolve issue number one by, creating a trust or, having a trust become a foreign trust or whatever it is, but then it has this ancillary sort of consequence that you maybe did not anticipate or foresee because there's some other thing going on in your life that may, cause that other consequence.
And I think it's about relationships too. I mean, it's not just what is the information on paper. And I think, as part of practice, we're meeting with clients, we're getting to know them, and we're going over the information on the questionnaire through conversation and through really just being interested to learn more about their family, because it's amazing what you'll learn when you just kind of let the client talk and explain the situation to you. There's other things that you'll pick up on that you wouldn't get from a questionnaire.
Absolutely. And broadly, where do you see your practice area going over time? Because I think, certainly what we're seeing and what you alluded to earlier is that just people are becoming generally more international in their lifestyle, in their focus, in their family dynamics. And I think that, technology will only accelerate that further, right? It used to be, I remember when I was a kid, speaking to my family abroad was a very expensive international long distance call. And, now it's clicking a button and being on a Zoom call and I'm looking at them, a moment later. And so I think that impacts the way people think about how they live their lives and where they need to be, because you can remain so much closer to somebody, even if they're thousands of miles away.
Right.
So, as we go into this age of AI and further, technological sophistication, where do you see your practice and practice area going?
Just only more complex, because families will only become more complex. So I think becoming more global is certainly the theme of all families, all high net worth families. They're going to have a footprint in some jurisdiction. And I think to your point of, we can just jump on a Zoom call. Where are people working? I mean, performing services in other countries. You can work from a laptop really from anywhere. And as you take that laptop and work in different jurisdictions, you can create a tax nexus. So it's really an interesting time that I don't think our tax laws have totally caught up with how global people are. And I think that's true of a lot of jurisdictions. I mean, they may not have rules on the books to address all of the situations that we're seeing, but I think the general trend is going to be families are going to become more global, more complex. There's a lot of fluidity that family members will go in and out of jurisdictions, and it's about keeping track of everybody. Can a family keep track of how many days they're in a particular jurisdiction? That's the other point, is that we have a lot of families that don't necessarily spend most of their time or all of their time in a particular jurisdiction. They're kind of in and out of different jurisdictions depending on the time of year it is. So it's about keeping track of all of the beneficiaries. What is their residency? It could be a full-time job.
Yeah. Yeah. I mean, this idea of the digital nomad that we talk about now didn't really exist just a few years ago, right? But now, people have the ability to work from anywhere for the most part. So totally different dynamic. And I think that's all the more reason why what you do is becoming more and more important every day. Because certainly we see issues today that never would have come up 3 or 4 years ago. Whether that's somebody, to your point, you can run a large business today from your laptop, sitting in Portugal or Spain or Italy or wherever it may be, and that
and just understanding what that means. So it's just about awareness. And I think for clients, it's if you're going to be in a particular jurisdiction, working in a particular jurisdiction, just understanding what the laws are so you don't run afoul of them and end up with a tax bill you weren't anticipating.
Yeah.
It happens quite often, and I think it's just more about awareness.
Well, I'll throw you a curveball you probably weren't expecting the answer, but you had alluded to working with local counsel in all these different countries. So obviously major cultural differences in every country. And I imagine that extends to the practice of law. So what are some of the things that in your experience really differ between the way that we think about law and tax in the US and maybe the way lawyers and lawmakers even in other countries think about those issues?
Italy's an interesting one. I mean, they have a particular regime where they were allowing people to essentially not pay tax on their foreign earnings. You pay a flat amount per year, and they just doubled it out of nowhere. And people were really caught off guard and upset about it. So that kind of a thing, it wouldn't necessarily happen in the US overnight in that way, right? We know legislation is coming and can anticipate it and do planning in advance of it. So I think that caught a lot of people off guard. What I would say is private client lawyers in other countries that I work pretty closely with, they're really tapped into this area. So they're really focused on working with global families and understand the needs, and they're familiar with taxes in other jurisdictions too. They're familiar with US tax, and that can make the advice for the client a lot more streamlined when you're working with a private client lawyer in another country that's focused on these issues.
Yeah, I think your firm, Dave Pitney in particular, seems to me to have been a little bit ahead of the curve in sort of recognizing the proliferation of family offices. Can you talk a little bit about that? Because one thing I think that's really impressed me is you and your colleagues have a deep understanding of the family office landscape, which it's funny, 15 years ago, nobody really used the term. I mean, a very limited number of people use the term family office, and now it's become this term that's become ubiquitous and kind of doesn't really mean the same thing to each person anymore. But how do you think about how sort of that landscape has evolved to where you have where everyone now has a family office, and that
in some sense,
and that differs to varying degrees.
Yeah, and it's about understanding what are the needs. What exactly do you want your family office to do? So we have a family office practice group at Dave Pitney, and it crosses through different segments of the attorneys that work at Dave Pitney. We have tax, we have regulatory attorneys, so SEC lawyers that work on it, as well as corporate lawyers. We work on establishing family offices, setting up funds for family offices. So we have a funds practice. I'm always looking at it from a global perspective, because a global family office is very different than the type of structuring that we're doing for family offices that have US people. That's all about hunting for deductions, character of income. Those same issues don't necessarily apply to a global family because they may not be subject to US taxation in the same way. If it's predominantly a family living abroad and they're inbound investing, we're managing the family office to prevent U.S. income taxation where there would ordinarily not be any. So preventing things like a U.S. trade or business. So we're looking at it, depends on what lens we're looking at it through.
Yeah.
To the point of families wanting to work together, one of the great things that we can do for a family, if they have part U.S. and part foreign, we can actually establish an entity here in the United States, and that will work really well for the U.S. family members because we can have that entity give us a good U.S. trust, a good U.S. investment advisor, so we have good US-based structures for our US family members. And we can actually have that same entity work with some of the foreign structures for foreign family members and not necessarily run afoul of any US tax principles by doing it that way. So I think it really depends on who in our group is looking at the issue, but we have the ability to help families, whether they're US or foreign, with a broad range of family office structuring.
Yeah, and I think one thing that you and your firm recognized early, which is really spot on, is that, within family offices, there are so many different types of legal issues that they'll encounter, whether it's tax or estate planning or investing or employment or, it's just the list goes on. And in a lot of ways, it's similar to the issues that a company needs to address, but it's also very different because you're not just dealing with a corporate balance sheet, you're dealing with many different individuals, many different objectives, considerations that go way beyond the scope of something that, a traditional corporate might be considering. So,
and whenever family's involved, emotional too, right?
100%.
There's the emotional side of it too.
100%. So I think that focus on family office that you've carved out is hugely important and not something that we see every day, because I think a lot of firms treat family offices like they're just another company. And it doesn't, as you know, it doesn't work like that.
Right. There's succession issues. There's it can be estate planning. It could be investment advisory. So there's a lot of different elements. And I think what's great about our firm is that we can draw from all of those different practice areas to provide holistic advice. So it's not just in the corporate department. It's cross-sectional.
Yeah, I think that's great. Well, I'm so happy that we got to not only do this show today, but also be reconnected after like 15 or more years. Thank you so much for being on. I'm excited about collaborating with you in the future.
Thank you so much for having me.
The information provided in this podcast is for informational purposes only and does not constitute financial, investment, or professional advice. The views expressed by the host and guests are their own and do not necessarily reflect the opinions of any organization or company. The host and guests may maintain positions in any securities discussed on the podcast. Always consult with a qualified financial advisor or professional before making any investment decisions.